Jai Hind, my friends. We will take 10 more questions from our series to learn more about Indian polity. And like always, do ensure the additional parallel learning through the images on the screen. Like here, the revisited 1823 Monroe Doctrine in recent times discussed again, and that stated that any attempt by the European powers to further colonize the Americas would be an unfriendly disposition towards the United States. And in the slides, you will see some more information related to the key aspects of India's foreign policy over the decades. So let's take the first question. How many of the following commissions are related to fundamental duties in the Constitution of India? Now, the first statement says First Administrative Reforms Commission of 1966. Now, first ARC has got really nothing to do specifically with the fundamental duties. And the second option says Swaran Singh Committee, 1976, or more technically, Sardar Swaran Singh Committee. This was appointed in 1976 during the times of emergency of 1975 to study and recommend the changes in the constitution. So it was this committee which had recommended the addition of fundamental duties in the Constitution of India. And some other important amendments which are also recommended by the same committee. They involved changes in the preamble, which you are aware, establishment of the administrative tribunals, and also limiting the scope of judicial review. Essentially, the legacy of this committee is what came to be known later as the 42nd Amendment of the Constitution. So definitely this is correct because this led to the introduction of fundamental duties in our constitution. Third is Justice J.S. Verma Committee, Jagdish Sharan Verma Committee, 1998. Actually, it should be 99, but that's okay. It was appointed in 99 in response to a 1998 Supreme Court direction to formulate a plan to educate the citizens of India about their duties. So G.S. Verma was earlier the Chief Justice of India, and the committee identified that many duties already have statutory backing. For example, the Citizenship Act, which ensures citizenship related duties, then Unlawful Activities Prevention Act, for communal harmony, national integrity, and also various environmental related laws, right, such as the Wildlife Protection Act. They also deal with fundamental duties to be enforced. So this committee emphasized on integrating fundamental duties into the educational curriculum at all levels and creating public awareness campaigns to foster a culture of duty rather than only rights. So this is also correct, 2 and 3. Fourth is Justice Geeta Mittal Committee. This was in the news earlier this year. So they were appointed in 2023, and they're supposed to submit the report by July this year. It's a 3-member committee, all women, to monitor the rehab work in the violence affected Manipur. So it has got nothing to do with fundamental duties as such. So 2 and 3 are the correct answer. We move on next question, and it says which of the following statements are not correct regarding the removal of the Speaker of Lok Sabha from the office. Interesting observation. Hardly 20% of the people got it right, even though this has been in the news because against Mr. Om Birla, there was a procedure that was initiated. So this is current affairs. We should have solid preparation on this. So statement 1 says, the notice of the resolution of removal of speaker shall be submitted to the deputy speaker of Lok Sabha. Now, this is where comes rule 200 of the rules of procedure of Lok Sabha, which states that the notice of the resolution, it shall be submitted both for the speaker and deputy speaker. It has to be submitted to the Secretary General of Lok Sabha. Okay, remember, speaker, deputy speaker, both. It goes to the Secretary General of Lok Sabha. First statement is wrong. Second statement says it is no leave of the House is required to take up the resolution of the House. You can think logically also. Removing the speaker is a very serious business of the House in the rules. So leave will be required. And how is that granted? That is required by not less than 50 members rising in the House when they are called upon to show their support. So leave of the House is required. Second statement is also wrong. Then the resolution to remove the speaker needs to be passed by a majority of the members present and voting in the House. Now, this is actually wrong. This is a very straightforward provision from Article 94 of the Constitution, where it requires effective majority. Okay, effective majority. That is the majority of the then membership of the House. You should remember that this majority is required only for the purpose of the removal of presiding officers of the house in their house. So, Speaker or Deputy Speaker of Lok Sabha or of the State Assembly or the Chairman or Deputy Chairman of Rajya Sabha and the State Legislative Council. So, all three are incorrect. That's what the question is asking as well. Next question is asking again about the process of the removal of Speaker, which are the correct options. First statement says the ground for removal has to be violation of either the Constitution of India or the rules of Lok Sabha. Now, neither the Constitution nor the rules prescribe any ground to be required. So there is no ground actually. So this is not correct. Then the speaker has the right to speak in and take part in the proceedings to consider the resolution of their removal, but does not have the right to vote. Now, this is where comes Article 96 of the Constitution, and that's not really necessary to remember the article number. Your logical derivation shall be strong enough. See, since during the removal process of the speaker, he or she cannot preside over the sitting. They can only be present in the house as a regular member of the house. So they can speak and also vote like any other member. And this voting will be in the first instance itself, right? Unlike the regular business of the house where the speaker votes in the second instance only. That is when there is a situation of tie. So both these statements are wrong. Then next question says correct regarding the joint sitting of the two houses of parliament. Now, the Constitution of India specifies that it shall be presided by the Speaker of Lok Sabha. Yes, that is correct. Now, this is where comes Article 118. In fact, I'll bring that up for you, where it very clearly says that the president, where it very clearly says that at the joint sitting of the two houses, the Speaker of the Houses of People or in their absence as per the rules shall preside. So it is mentioned here that the speaker shall preside. Then further, if you see clause 3, it says the president after consultation with the chairman of the council and the speaker may make rules as to the procedure with respect to joint sittings. So if the speaker is not there, then in their absence, these are the rules which help us decide what will happen. So that's the second statement. During the absence of the speaker from such sitting, the deputy speaker of the house, or if he or she is also absent, the deputy chairman of the council of ministers shall preside. Now, this is a correct statement. This is as per the rules. So first statement, second, both are correct statements. And then the third statement says, during the absence of the presiding officer of both the houses, such other member of parliament as may be appointed by the president shall preside. So this is wrong. It is not the president who will decide. In this case, it is the houses together who have assembled for joint sitting. They will decide who will preside on that particular day. So the third statement is wrong. And see, considering the recent focus on Lok Sabha, etc., 20% people getting this right tells me that as a community of aspirants, some better focus is required to prepare them properly. These are straightforward provisions, not needing too much interpretation also. Okay. Anyway, let's move on to the next question. The rules related to the procedure with respect to the joint sitting of the two houses of parliament are made by, I already showed you Article 118, Clause 3 earlier. The correct answer is the president. Okay, the third entity of parliament. So president shall be the correct answer. Rest everything is just nonsense to confuse. Then, which of the following statements is are correct regarding breach of privilege and contempt of the houses of parliament? Now, so first, let's be clear what is privilege and what is contempt. As a general idea, privilege, these are certain rights that are enjoyed by each house collectively and also by the members of each house individually, without which they could not discharge their functions. And they exceed those possessed by other bodies or individuals like you and me. So they have more than us. When any of these rights and immunities is disregarded or attacked, that offense is called breach of privilege. And it is punishable, breach is punishable under a law made by parliament. Now, contempt, it is an act or omission, right? It could be commission, omission, both. So it is an act or omission which obstructs or impedes any house of the parliament or any member again or any officer of the house also in the performance of their functions, discharge of the duty. Very logically, every breach of privilege is a contempt. But there can be a contempt where actually there is no breach of privilege. A simple example would be a person shouting slogans from the visitor gallery or throwing leaflets. Now, that is contempt of the house. The house cannot function. It's not breach of privilege, really. So, in that background, if you see, all breaches of privileges are contempts of house. That is correct. However, a person may be guilty of a contempt even though does not violate any of the privileges of the house. That is also correct. So, both are correct statements. Then, with reference to the Representation of People's Act, an election petition can be filed by candidate, elector, resident. So this is where section 81 of the RPA 1951 comes in the picture. And also as a general principle of every election, remember, only the interested parties of an election can file an election petition. That is the candidates and the voters of that election. Resident, etc., has nothing to do. You have to be a registered voter elector. So 1 and 2 both are correct statements here. Then, when a bill passed by the state legislature is presented to the governor for assent, which of the following choices are not available with the governor? Now, this is in reference to the presidential reference that was made last year in 2025 after the judgment of the court with respect to Tamil Nadu governor's actions. So, President reference has now clarified the position on this matter. So, let's see. Now, when we say absolute veto, this is not available for the governor. And let's be very clear, what is absolute veto? Court has held it to mean a situation where the governor withholds the assent to the bill, right? And withholds assent simpliciter, which means the governor rejects the bill without giving any reason. So no reasons have been given. Governor has to give reasons, and when reasons have been given, it would automatically follow the route of suspensive veto. When you have given reasons, that is, it will go back to the state legislature. So governor can withhold assent with reasons. So withholding assent is still a power, okay, but reasons are to be given. So in that sense, suspensive veto remains as a power. Absolute veto is not available. And there is no space in the constitution for inaction. Hence, governor enjoys no pocket veto also. If there is any unexplained delay, courts can issue a limited mandamus also to the governor to take action on the pending bill, right? So second only is available, first and third are not available. And let's summarize this to be very clear. Governor can withhold assent, but they cannot withhold assent simpliciter, so absolute veto is not there. They can withhold assent only by giving reasons, or they can just return the bill also. Both things ultimately will be like suspensive veto. It will go back to the Legislative Assembly, and the governor has no pocket veto. So, next question. Which of the following statements are correct regarding the governor's powers with respect to the bill passed by the state legislature presented for the assent? Continuation of the previous one only. And the first statement says merit of the governor's decision is not justiciable. Now, this is a correct statement. What it means is the courts cannot question why or why not the governor has taken a specific decision. Courts can examine delay and issue mandamus, as I told you earlier, but they cannot question why the governor chose whatever they chose amongst the options we saw in the previous question. They are the discretions of the governor. So the merits cannot be examined here. Then if there is prolonged inaction, courts may issue direction. We have seen already that is also correct. And the governor can act independent of the advice of the council. Absolutely correct. Right? So all the powers that are given, governor can use their own. On see, now this is the most important topic from the governor in the last 1 year. And still hardly 20% of us are able to get it right. We need to pull up our socks. Then the last question for this video, it says, according to the Constitution of India, how many of the following statements are correct for the governor reserving a bill for the consideration of president? First, the president may withhold assent. Yes. And very much like the governor, they must give reasons when they do this. It cannot be simpliciter. Okay. Same as governor. Then if the president decides to return the bill to the houses shall reconsider it within a period of 6 months. That is also correct. This is a stated provision of the Constitution of India under Article 201. Then if the president decides to return the bill, to the legislature, and if it is again passed by the houses, it shall be presented again to the president for consideration. Now, that is also correct statement. Common sense also. Once the governor gets involved, then it has to be presented again to the president. Governor cannot take a decision by themselves. Then the fourth statement says if the president decides to return the bill to the houses of the state and it is again passed by the houses and it is again presented to the president for consideration, then the president cannot withhold assent from the bill. Now, this is wrong. There is no limitation on the president in this case. Normally, we know that when the head of the executive of the union or the state, they receive a bill for assent second time, they shall declare assent. However, in case of the state bill coming to the president second time, all powers are intact. President may withhold assent with reasons or return it with comments again. Remember that this is technically a relationship between the state and the union. And president is only a name that symbolizes the union government. So only 1, 2, and 3 are correct. That is all for this video. I hope you got some more clarity and understanding of the relevant topics. Keep working hard. All the best.